Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello, I'm Natalia Angelini.
And I'm Geoffrey Sculthorpe.
Welcome to Hull on Estates. You're listening to episode number 721. Today we're going to be discussing a change in the Quebec family law framework, which we sort of came across this recent article by Scotia Trust that grabbed our attention. And it's all about the introduction of the Parental Union regime, which takes effect really soon. So maybe, Geoffrey, we can dive in.
For sure. Thanks, Natalia. First I want to start with talking about a little bit of background and context here. So common law unions are much more common in Quebec than in other parts of Canada. In 2021, 42.7% of couples in Quebec were actually in common law relationships, compared to only 17% in the rest of Canada. But despite this prevalence, common law unions in Quebec have historically had very limited legal recognition. Under the Civil Code of Quebec, these relationships did not and still do not technically attract the same legal consequences as marriage, particularly in areas of property division, spousal support, and inheritance. This limited legal recognition was affirmed in 2013 by the Supreme Court of Canada in Quebec Attorney General and A case, where the court held that individuals who choose not to marry are choosing to avoid state-imposed legal obligations, stating that those who choose not to marry gain the opportunity to structure their relationship outside the confines of the mandatory regime applicable to married spouses. While the court did state that, it also further went on to note that the legislature does have the authority to change this framework if it sees a social need. And it specifically actually said that it will be up to the legislature to intervene if it, being the legislator, believes that the consequences of such autonomous choice give rise to social problems that need to be remedied.
Yeah, and that sort of brings us to the parental union regime, which I see as a way to try to, I guess, bring things to closer reflect what's happening in modern society, right? Which is there's, like you said, a larger amount of common law unions in Quebec. I'm kind of surprised about the small percentage elsewhere.
Me too.
But yeah, so I see that as really they're trying to, I guess, deal with this gap in the legislation. So what the Quebec legislature is going to do, and takes effect June 30th, so it's just around the corner. So it's a new legal framework, and it's applying to some unmarried couples through this regime, and it's introduced through Bill 56. And the regime automatically applies to unmarried couples who live together, who present themselves as a couple, and who are parents to the same child. But that child has to have been born on or after June 30th. So it's going to be applying from June 30th forward, kids born from that time. So no retroactive effect for this one. And so couples that fit all of those parameters, they're presumed to share a community of life, which is a key criterion to fall within this regime.
Yeah, so that's how I understand it, and then I guess now I can discuss some of the key features of this specific regime coming in Quebec. So under this regime, something called Parental Union patrimony is being created, and this includes certain assets. That are used in this relationship for family purposes. So some of the assets that fall under this parental union patrimony are the family residence, furniture used in that household, so in the family residence, and any vehicles used by the family for family travel. And so this changes the current law in Quebec, because now legal ownership does not determine the division of these assets. In the event of a separation now, these patrimony assets would be subject to equal division between the partners.
Right.
One of the things that's important to note, however, that this is not a full scope regime, and there's lots of things that are excluded from this patrimony, so to speak. So the patrimony does not include any secondary residences, any rental or investment properties owned by either common law partner, either of their retirement savings, such as an RRSP, or any inheritances or gifts received by either of the partners.
Yeah, interesting. And I also understand that there's some additional potential like legal consequences. So there may be there's some ancillary rights, right? So one partner may say, well, I should be entitled to a compensation allowance because my conduct has effectively enriched my partner to my detriment, right? So there's that kind of, I guess, opportunity for someone to claim some compensation. And if one of the partners passes away and there's no will, the surviving partner can now or may now inherit. That was a right before that was only reserved to married spouses. So that's another interesting additions. And there's also protections for the family residence. So if a couple separates, let's say, what the parent who's got the, I guess, custody of the child can stay in that home for up to 120 days, regardless of the legal ownership of the home.
Mm-hmm. Yeah.
So yeah, that's it's interesting. Some of this to me seems really progressive, and some of it's I still see some I see some where some more tweaks may help. But over to you, Geoffrey.
No, for sure, for sure. Like I think like those consequences of the regime that you mentioned are pretty straightforward and make sense and are progressive.
Yeah.
But there's definitely still some gaps, and I mean
Mhm.
I'll talk about some of them right now. But
Sure.
like the couples can opt out of the regime in part or in full if they want, and there's even other certain limitations to this proposed regime. So there's obviously always going to be the question about like why did they only go so far? How did they make this decision? But
Yeah.
when we're talking about opting out, the couples are allowed to opt out of the regime or exclude specific assets from the patrimony through a notarial agreement. So, I mean, I think the point behind this is it provides flexibility for those individuals who do not want to be subject to all the provisions of the regime. And then there's even further limitations to this regime, which I think are actually really even more require more consideration. As
Mhm.
you mentioned this earlier, like couples with children born or adopted, it only applies to couples with children born on or after June 30th. So it doesn't act retroactively at all.
Yeah.
And also the couples it only applies to couples who are recognized in a common relationship at the time that child is born.
Right.
I think those are two really important things to consider, right? Like if you had a child before this, this regime wouldn't apply to you. And if you are not recognized as being in a common law relationship at this time that goes into effect, it would not apply to you.
Right. Right. Yeah, and so it's a good I mean it's because this is just right on the cusp of coming into effect. It is a good time for I guess professionals practicing in Quebec to be aware of this, and for people who are living in Quebec to be aware of these changes and these understanding these legal consequences. Right, we're always going to say get legal advice, and there's tools to manage some of these consequences outside of this, right? Like prenuptial agreements, cohabitation agreements, gifts or inheritance protection clauses in, estate planning documents, having clear and updated estate planning documents. So, those are always things that we encourage. And the key message really is, hey, now, even though you're not married, there's going to be some new rights that you have and some obligations potentially that you have.
For sure, for sure. I mean, like we always say, like in all that we put out, always speak to your lawyer and
Yeah,
preferably a lawyer in the jurisdiction where the law will apply to you. Um,
right.
but I think it's really important to emphasize kind of where the parental regime doesn't fall, what that doesn't cover, because there are some significant gaps. So
Mhm.
common law, this regime does not apply to common law couples without children. It
Right.
does not apply, like I said, to couples who had children before the cutoff date, so it doesn't apply retroactively.
Yeah.
Really importantly, blended families, it doesn't apply to unless the couple does have a child together. So if you get together with someone and both have children from your previous marriage, the regime wouldn't apply to you. Um,
Yeah.
and notably, we talked about some of the rights it does provide you. It does not create routes to spousal support between common law partners. I
Yeah.
think that's really important to note.
Yeah.
And now I think we should move into maybe bring this back. Like, we're based in Ontario. Most of our
Yeah.
work is in Ontario. So we kind of want to talk about how this Quebec's parental regime, this new regime, is different or contrasted from how we deal with common law couples in Ontario and how they're treated currently,
Right.
our legislation. And
Right,
they,
and we're not family law lawyers. That's not our expertise. We can certainly, well, Geoffrey, you can maybe touch a bit on the family law side as we kind of understand it on a high level.
yeah, because and you're going to touch on this in a little bit. We do some dependent support work that falls under the SLRA, and so that plays into this a little bit. But I'll let you get to that. I would say the two main ways that people in Ontario are treated in this regard is in particular in the areas of property division and spousal support. So when it comes to property division here, unmarried couples in Ontario do not have the same rights as married couples regarding their division of property. In fact, the Family Law Act's matrimonial property regime applies to married couples and does not extend to common law partners. Instead, in Ontario, unmarried partners must rely on common law and equitable remedies, such as claims of unjust enrichment or constructive trust, to seek a share of property acquired during the relationship. And then when it comes to spousal support, the Family Law Act does actually extend some spousal support obligations to unmarried partners, which is probably a good thing. But you have to be able to show that you have cohabitated continuously for the last 3 years, or are in a relationship of some permanence and have a child together. This is reflected in Section 29 of the Family Law Act. And I think overall, these things, while they do offer some protections, it does make it more expensive and arduous for unmarried partners to receive any remedy should there be a separation, because they need to go to court to receive either of these remedies.
Right, they've got to prove their entitlement, right? And just like in, switching over to estate matters, should you be in a couple and one of them passes away and you're not married, the Succession Law Reform Act is what governs, and we deal with lots of dependent support claims by the surviving partner. And sometimes it's a real frustration when you've got these 20, 30, 40-year common law relationships and you've got to prove, right, that you're a dependent. And then you get into there's many factors that the court considers when it looks at this kind of support to award. It's under Section 62 of the Act. And, there's fights over quantum of support and whether interim support should be paid while the litigation's going on. Like, it can get so expensive and costly. And so I guess therein lies the subtle encouragement that continues maybe for people to get married.
Yeah.
Put a ring on it, as Beyonce would say. But it is good to see that Quebec is kind of, changing things. Things are in flux. Things are changing to recognize.
Yeah, and especially because obviously, based on the statistics, like it is much more prevalent.
Yeah.
Right. So they're addressing a difference in their population that isn't seen in the rest of Canada, which in itself is progressive, I would say. So
yeah, and and I'm sure we're going to see those percentages increasing all over as time goes on.
100%.
But there you go. I think that was an interesting one.
Yeah, it was great. Well, so I think that concludes our podcast for today. Until next time, we want to thank you for listening to Hull and Estates. Again, I'm Geoffrey Sculthorpe.
And I'm Natalia Angelini. Should you have any questions, please email us at info@hullandhull.com or contact us through our contact page on our website. Thank you.
Thanks, Natalia.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.